Hello, it's Roger Royce, tax and corporate partner with Haynes Boone, downtown Palo Alto. I do emerging growth and venture capital. And even though most of what I do is startups, from time to time, I will work with a partnership or an LLC, which is why I want to talk about an interesting Delaware case that came down last January of 2024, Cantor Fitzgerald versus Ainslie. And the case is interesting because it examined forfeiture for competition provisions of limited partnership agreements. Now, oftentimes in limited partnerships or LLCs that are organized as service arrangements, the governing document, be it the partnership agreement or the LLC agreement, will provide that when somebody leaves the company, they get distributions over a period of time, provided that they don't compete. And once they start competing, they don't get distributions anymore. That's at the highest, simplest level. And that's what we had in the Cantor Fitzgerald case. If a partner had left the entity, engaged in what they called competitive activity or breach activity, and that determination was made in good faith by the general partner, well, then their payments would stop. In the payments that they were about to get, the departing partners would go over a period of about 4 years. So in effect, it was a 4-year non-compete. Now, several of the partners left, and they got some payments because there's a base amount that they get back, but they didn't get these additional conditional payments. Because they had gone to work for competitors, and they all did that within the first year. So they got very little. And they went back into court and sued on the basis that this forfeiture for competition provision should be declared invalid as a unenforceable non-compete. Now, keep in mind, in a lot of states, like here in California, an employee non-compete is generally just is not only unenforceable, but under a recent provision in California law, it's downright illegal. It can get the employer in a lot of trouble trying to enforce those. But keep in mind, these are not employees; these are partners, and it's not California; it's Delaware. So, nevertheless, the lower court, which in Delaware is called the Court of Chancery, took a look at the cases involving covenants not to compete, most of those dealing with employees, by the way, and said, Delaware has an interest in protecting competition that outweighs Delaware's interest in enforcing contracts, and we're going to subject them to a reasonableness scrutiny, because that is the test in a lot of states that are not California. And they just determined that it wasn't reasonable. 4 years is just not reasonable. So they held this forfeiture for competition provision to be unenforceable as a policy matter, as an unreasonable and therefore unenforceable non-compete. The Delaware Supreme Court reversed. Okay, they reversed a 36-page opinion, and they went to a lot of trouble in the case to draw a distinction between non-compete for which somebody breaches and they can be sued for damages, to distinguish that against a forfeiture for competition provision, which basically says the non-compete part is a condition precedent to getting a payment. And they went ahead and reversed and held that it was enforceable. And even though they gave a lot of lip service to that, I think maybe some might say a little bit artificial distinction, I think they really hung their hat on the fact that Delaware really holds freedom of contract in high regard. And that is one of the reasons we always form companies in Delaware, because you can take comfort that the Delaware court is going to enforce what you agreed to and not come in and try to rewrite your deal. And that's what they did right here. And in fact, they said only a strong showing that dishonoring a contract is required to vindicate a public policy interest, even stronger than freedom of contract, will induce our courts to ignore unambiguous contractual undertakings. They did mention the fact that these were sophisticated actors. They, of course, mentioned the fact that these were partners, not employees. And interestingly, they mentioned the fact that the partners who were suing the company to avoid these contract provisions benefited from them while they were partners and other partners left the company. But basically, if you wanted to get technical, you'd say what they said is, this wasn't really a restrictive covenant, it was a condition precedent, and that's different. And therefore, we're going to go ahead and enforce it as it is written. So just keep in mind, though, that these are really tricky things to do. I think you have to be careful. You have to look to state law. Different states are going to look at this differently. And if it is a restrictive covenant, then of course, you're going to have more of a balancing of the equities. But in this case, Delaware has spoken, and once again, it is upheld freedom of contract. Roger Royce, Haynes Boone, Palo Alto, California.